Are we there, Bobby?
Not yet. One moment. Okay, we are live.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
Good morning. I welcome you to the October 7, 2020 settings of 7th Court of Appeals, appearing through Zoom and YouTube. We appreciate the attorneys being willing to participate this way, and God willing, things will be changed and we can see everybody in person soon. We'll go on and call the docket. First case we have this morning is 07-19-00039-CV, Glenn Younger and Ruth Younger versus Alan Younger, Gail Younger, and Michael Younger. For the appellants.
Russell Frost here on behalf of appellants Ruth and Glenn Younger.
Thank you. And for the appellees?
Michael Morris on behalf of Glenn and Gail Younger, Your Honor. Alan?
Thank you.
Thank you.
And as you've been informed, both sides have 20 minutes for the presentation, and of course the appellants have an additional 5 minutes. I'm not sure either one of you have appeared before our court. We do tend to ask questions, and we appreciate quick responses. And sometimes our questions are just kind of a devil's advocate scenario. So please do not read more into the questions than actually they're being just questions. So with that, we'll go on, and well, let me ask you, both of you can hear us all?
I can hear you, Judge. Thank you.
Yes, Your Honor.
Judge Parker, can you say something, make sure we can hear you?
Good morning.
Morning.
Judge Doss?
Good morning, y'all.
Good morning, Judge.
Sir.
Okay, Mr. Frost, you've got the floor, or the camera.
Thank you, Chief Justice. May it please the court, my name is Russell Frost. As stated, I'm here on behalf of Ruth and Glenn Younger. I'd like to reserve 5 minutes for rebuttal. The issue before this court is whether Alan Younger, his wife, or his son have acquired any vested interest in the property of this trust. And the clear answer under the interpretation of this trust is that they have not. And we're asking this court to interpret the trust as it is written. We're asking the court to reverse the judgment of the trial court and render a declaratory judgment consistent with our pleadings in our briefing, namely that under the trust and as a result of Ellis's death, no trust assets passed to any of the plaintiffs. The corpus of the trust passed to a survivor's trust for Ruth's sole benefit. Alan was only ever a contingent beneficiary. Alan is no longer a contingent beneficiary, and Alan nor any of his family members have any vested or contingent rights under the trust or to any of the property which may be held by the trust. And further, Judge, just to conclude my opening, we're asking that this court render a take-nothing judgment for the appellees, and we're asking to be awarded attorney's fees under Chapter 37 of the CPRC and Chapter 24 of the Texas Property Code. Unless the court has questions, I'm ready to field them, but I'd like to begin by laying out the structure of this trust. It is the court's job to interpret this instrument based upon the four corners of the document. Nobody here is disputing that. We're not looking to any outside evidence. Nobody has pled for ambiguity. Both sides believe this trust is unambiguous, and both sides are asking the court to interpret it as written. So let's take a look at the, yes, Judge.
May I interrupt real fast? Just a matter of background. Is the only instrument in play the trust, or was there some type of will executed along with the trust, or something like that?
Judge, the only instrument in play here, the only piece of evidence before the court, the only issue before the court is this trust agreement. That's it. There is nothing else. Go ahead, Judge.
Will the record reflect that there was a will?
The record will reflect that Ellis did have a pour over will, correct?
And is there any property that is going to be transferred outside the will, or was everything poured into the trust?
For the purposes of this appeal, all the property that matters was poured into this trust. Okay.
Thank you.
All right. And to be even more specific, Judge, I think that the only property at issue here is specifically Ellis's half, or I'm sorry, one half that has been designated as a separate share for Ellis. So his half of the community interest went into a separate share. And I'll walk the court how we get there in just a moment. But the broader picture of this trust, and the table of contents is instrumental here. We can look at Articles 1 through 4, and we can determine that these are the rules that applied when both grantors were alive. And we can look at Articles 5 through 7, and we can determine that generally these are the rules that apply when one grantor is passed, which is the case here. And by the way, there are two facts relevant to this case. One, Ruth is alive, and two, Ellis is dead. That's it. Those are the only facts, and they are not in dispute. The Article 8 and some of the provisions thereafter deal with the situation where both grantors are deceased. Okay, we're not there yet. We're not in the first part. We're not in the second part. We're in that middle part. Those are the rules that we're dealing with here today. And I'd also note that by looking at the table of contents of this trust, we can see that there's two obvious purposes behind this trust. Undisputable, obvious purposes. Concerns about estate taxes and providing for the surviving spouse. That's the purpose of this trust, and it is apparent from the trust instrument itself. The simplest solution for this court to resolve this case, I think, is to acknowledge that no appellee here has any vested interest in this trust whatsoever. Allen was at one time a contingent beneficiary. That's not disputed. He isn't any longer. Ruth amended the trust. Ruth had every right to amend the contingent beneficiaries under Section 7.2.
Let's stop there for just a minute. Suppose we don't have the situation where we have an attempt to amend the trust. What happens there? Who takes?
Good question. As of right now,
I'm not talking about right now. I'm saying, consider the hypothetical where there was not an amendment. What happens under those circumstances?
In the event that Ruth passes, or right now?
With Ruth currently being alive.
With Ruth currently being alive, there's no difference whatsoever between the original trust terms and the current trust terms. Under the original trust terms prior to its amendment, right now, the rules that apply are Article 7. We don't get into Article 8 until Ruth passes. So that whatever changes occurred in Article 8 are moot as of today. They will only become relevant once Ruth passes. And
right.
we know
you would agree with me that but for the amendment that Ruth attempted, the appellee would actually have an interest in property, whether it be contingent or vested.
I would agree that but for the amendment and subject to all of Ruth's rights under Article 7, including to move all of the assets from the separate share into the main share, including unfettered access to the income, including unfettered access to the principal, and that's 705 and 706. And really, this is dispositive, Judge. The unfettered access under 7.09 to appoint who gets the property from the surviving trust, all before Article 8 ever kicks in. That's what Article 7, Section 7.09 says.
Okay.
And so if your question is, go ahead. I'm going to try to get your question.
My question is this then, if your argument is based upon Ruth's right, whether it exists or not, to amend the trust, then if she doesn't amend the trust, the appellee's got something. What something does the appellee hold under that hypothetical?
As of right now, nothing. A potential, if the trust wasn't amended, and if there's any assets in the trust when Ruth dies, because she's got all these remedies in Article 7 to deplete it if she wants, and it could be that she already has, then and only then do we get to Article 8. Whatever is left over when Ruth dies at the end of Article 7, we are directed to pass that forward and distribute it under the terms of Article 8.
Well, how do you square that with the language in section 5.02 that says that upon the grantor's death, our trust will become irrevocable as it pertains to the administration and distribution of the deceased grantor's trust property?
Good question. This is a conduit of trusts, and you have to understand that there are trust rules that begin when both grantors are alive. There's a different set of trust rules when one is dead, and there's a different set of rules when two die, okay? And so with regard to your question under 5.02, once Ellis passed away, what became irrevocable was the gift, was the funding of the administrative trust for tax purposes, okay? That's where his half goes. And this is laid out in the trust in section 5.02. If there's any tax issues at the time Ellis passed away, we would deal with that through this administrative trust. But if there aren't, or if there's anything left over, we're told that whatever's left over falls into the survivor's trust and is held as a separate share under the survivor's trust, under the control of the survivor's trust. So what can't be revoked, what becomes irrevocable, is the gift that goes into the administrative trust. And then after estate issues are dealt with, tax issues, the rest goes into the survivor's trust.
If we're talking, though, the language contains the word distribution. If we're dealing with distribution, how can the distribution of Ellis's intent be changed after Ellis's death?
His intent was that the property be distributed into the administrative trust and the survivor's trust. That was his intent. That's the only intent that matters here. And that's what happened with this property. The property factually was at Ellis's death, community property, 50% was allocated to the an admin trust to deal with admin issues. 50% was allocated directly to the survivor's trust. There were no tax issues for the deceased grantor's trust property as defined in 5.01. And so that fell into the survivor's trust, and that's where it is right now. But it's being held separately for tax reasons. And this is important. I want to direct.
Okay, so Article 6, doesn't it provide that the separate share may not be amended?
Article 6 deals only with tangible personal property, which is not at issue in this case. The only issue, Article 6 disposes of the tangible personal property. And by the way, it disposes of it to Glenn, my client. Okay. Whatever is left over after Article 6 is the intangible personal property, for which there is none, and the real property, for which there is only a 1/2 interest in the homestead community property. That's it. And so Article 6 is instructive only insofar as it requires that the residuary distribution in 6.05, the deceased grantor's remaining property will be administered as provided in the following articles. So we look to Article 7. And under Article 7, the way it should be set up now is there is a survivor's trust. Ruth is the sole beneficiary. She is also the co-trustee with Glenn. Under Article 7, look at the rights that she has before we ever get to Article 8. Under Section 7.2, she has the absolute right to amend the survivor's trust. Under 7.04, the third paragraph, she has the absolute right to take anything set aside in the separate share. And again, the separate share, this is property that was required to be put into the separate share by the terms of the trust, But once it's in there, she can move it to the main share if she wants. It says it right there in the third.
Explain to me the separate share. I know opposing counsel mentioned that, and if I interpreted his brief right, he was indicating that the separate share meant that that was supposed to remain separate and in effect be divided up among the kids, as opposed to be melded and allowed the survivor to do whatever they want.
And
So explain
that's,
to me that.
yeah, Judge, that is not a correct interpretation. What this separate share is designed to do is avoid tax liabilities, okay? Under 7.04, the surviving spouse, okay. I'm sorry, I lost my train of thought moment. The separate share is set aside for the purpose of making that portion irrevocable. When it becomes irrevocable, it becomes a qualified trust. When it becomes a qualified trust, required minimum distributions, there are tax benefits for that reason. So if the surviving spouse is receiving required minimum distributions, they can pass through this trust, and the income is stretched out over a period of time to reduce tax liability. This section has to be read in conjunction with section 11.1, which discusses this. It has to be read in conjunction with that. And so that is the purpose of the separate share. But regardless, Ruth retains the right to liquidate the separate share into the main share, and she has the absolute right to liquidate all of the income and all of the principal of the trust if she wants to under 705 and 706. And again, before we ever get to Article 8, under 7.9, she chooses where the corpus goes if she makes that power of appointment. We can't discuss Article 8 until Ruth dies. It is not at issue here. And in all likelihood, when she passes, there won't be any property left in this trust. She will have made the general power of appointment under 7.09 as she deems fit. And any interpretation otherwise, in particular the trial court's interpretation, I just don't understand how the court could have ignored this entire provision and completely misinterpreted this trust. This is a standard trust designed for wealthy folks who need advanced estate tax planning. And the Ellises really didn't need all that advanced estate tax planning. Maybe they bought too much estate tax planning. But in any event, they got a good document. The problem here is that the trial court just didn't interpret it properly. And my clients are asking this court to, on de novo review, take a look at this document on the whole, recognize its purposes. 1, to avoid taxes. 2, to provide unfettered access to the corpus for the surviving trust. 3, to let the survivor decide where any of that money goes under 7.09. And then and only then, if there's something left over, we're going to look at Article 8 and figure out what goes on there. But guess what? We amended that, and we had the right to do it.
You would agree with me that the phrase separate share is not defined anywhere expressly in the trust document, right?
No, Your Honor, I would disagree with that. Section 7.04 expressly discusses at length what a separate share is. The second paragraph, and this is important, Judge, the second paragraph of 7.04 says the purpose of the separate share. The purpose of the separate share is to keep the deceased grantor's trust property and its accumulated income separate from the main share during the lifetime of the surviving grantor in order to qualify the separate share as a designated beneficiary under qualified retirement plans and to avoid the possible disqualification of the federal estate marital deduction under the IRC 2056.
If that says it, I'm sorry, go on.
No, go ahead.
If that says it's supposed to remain separate, how can survivor blend it?
Because they're allowed to blend it under section 704. The third paragraph says, our trustee shall distribute as much of the principal and accumulated income of the separate share to the main share of the survivor's trust as the surviving grantor directs in writing, which Ruth may or may not have already done. This right to direct distribution from the separate share and the main account may be exercised only by the surviving grantor.
So we have a provision that says it has to be separate, and then we have a provision that says, well, it doesn't have to be separate.
Okay, let's look at those provisions. This provision, the one that says, but the surviving grantor may not amend the terms of the separate share. Okay, everybody looking at that sentence, the third sentence in 7.04. The reason that sentence is in there is to make that share irrevocable, specifically the gift from the into the administrative trust and then into the share. Because if it's not held separately, there could be tax consequences for Ruth. That's the whole purpose of all of this. We keep it separate so that we qualify, so that the trust is a qualifying trust. That allows us to take our required minimum distributions and string them out over a period of time to minimize the tax liability. This is a standard form trust. This is the way that estate planners do it. I do not see any ambiguities to the extent opposing counsel has found some provisions that he believes are inconsistent and got a few folks to agree with him. My hat is off to him.
Let me ask you this question with regard to the third sentence of section 7.04.
Okay.
Their surviving grantor may not amend the terms of the separate share. If you cannot amend the terms of the separate share, then aren't the terms effectively amended under your argument once it's brought back into the main share?
No. What we can't amend is the gift that happens automatically, the transfer that happens automatically on Ellis's death. And that is from the corpus, we're going to split up their property, as I discussed, and Article 5.01 gives us the definition of how we're going to split it up. So we're going to have surviving grantor's trust property, and we're going to have deceased grantor's trust property. Okay. What is irrevocable is that property that has to be split like that. Half has to go into the survivor's trust. Half has to go into the administrative trust if there are tax issues. Here there weren't. Afterwards, it falls directly into the survivor's trust, but we hold it separately. And it says right there why we're holding it separately. It's not for a contingent beneficiary down the road. It's for tax issues. We're holding it separately. The purpose of the separate share is to keep the deceased grantor's trust property separate so that we can qualify for these tax benefits. It could not be more clear. There are no inconsistencies here. If the court doesn't have any additional questions, I will conclude by asking the court to reverse the judgment of the trial court, render a declaration consistent with our pleadings and briefing, interpret this trust as it is written, de novo, and we're going to need a few declarations so that we can go forward with our eviction, which started 2.5 years ago. We need a declaration that no trust assets passed any of the plaintiffs.
Okay, counsel, your time's expired, and you do have 5-minute rebuttal.
Thank you, Your Honor.
Thank you.
Good morning. May I proceed, Your Honor?
Morning,
May it please the court.
counsel.
This is a beautiful little piece of farmland out in Guadalupe County, Texas, outside of Seguin. On this farmland, both parts of this family have resided for more than 30 years. It's divided into 2 parcels, parcel 1 and parcel 2. And when this trust was created, Ellis and Ruth both agreed this parcel goes to Glenn, this parcel goes to Alan. Both of those children, adult children, had their own families. Both of these adult children had their own homes. And both of these adult children have lived on this property consistently for the past 30 years and continue to live on there today. The problem is, what really was Ellis's intent? There is another document that's a part of the record that the court needs to consider, and that's Ellis's will, which was generated simultaneously with this trust. In it, Ellis says that the trust property must be administered according to the trust and amendments made prior to my death. It also says property held for the benefit of my beneficiaries will be under the same terms and conditions of my revocable living trust as it exists at the time of my death. Ellis had a very different purpose than what the appellants claim in
Now,
creating.
that was
the
his
trust.
will that said that?
Yes, sir.
Does the trust refer to the will in any way?
I don't know the answer to that, Your Honor.
I'm
I know
not
that-
opposing counsel answer that because he's shaking his head no, and he's about to look for something. So anyway, okay, anyway.
I know it's a pour-over will, so it mentions the trust significantly. They were drafted at the same time, and the Voller law firm intended for them to both be hand in hand. I don't know that the trust backwards reflects any of the will provisions. I don't believe that's true, actually.
Well, and were Gail Younger and Michael Younger, were they beneficiaries of the trust?
No, Gail is Alan's wife.
Right.
Michael is the son. So Ruth and Glenn had filed an eviction proceeding after they created this amendment that tried to disinherit Alan. And that eviction proceeding was to try and kick them out of the house they'd lived in for 30 years. Of course, as eviction proceedings go, you have to have all the parties involved who are residents within the house. So they had to be.
This proceeding, as I understand it, does not involve the eviction at all. It's only on the construction of the trust.
That's correct, John. What this proceeding was originally in the trial court was a temporary restraining order holding off that eviction. And so they had to be a part to the district court action to be able to claim that there was no eviction proceeding appropriate. And that's the only reason they're a part of it. They are not named in the trust. That is correct.
Does the record reflect what happened to cause them to try to write Alan out of the inheritance, so to speak?
The depositions of Mrs. Ruth Younger, I think, lay out some of the reasons why she began to trust her son Glenn more and more, because he was providing more of the caretaker responsibilities. He didn't have a job. Alan had a full-time job. Alan's wife had a full-time job. They were less providing of the caregiving instruction. And so it was really Glenn who was more involved in the day-to-day caregiving.
In this case, okay, this case is just straight up documented will, trust, not will, but trust interpretation. There's no claims of undue influence or anything like that to set aside the trust or anything like that.
We had all of those claims, Your Honor, at the trial court. And we were ready to proceed on every one of those claims, not only undue influence, lack of capacity, breach of fiduciary duty. We had all those ready. When the trial court made it abundantly clear that they saw the trust as two separate trusts, the deceased grantor's trust and the surviving grantor's trust, we made it abundantly clear that that was the result we needed. And we didn't need to challenge the amendment, to try and void the amendment, to do anything with the amendment, because the amendment's only going to be as to the surviving grantor's trust and anything contained therein. But the judgment of the trial court, and exactly what is reflected up here on the record, is that the deceased grantor's trust has already been giving an administration and a distribution to Alan. And that separate trust, that separate entity, is not affected by this amendment. And so at that point, we decided, let's keep the record clean. We don't need to go into the amendment. We don't need to go into the undue influence, but those were all absolutely issues we were ready to and prepared to go forward on at the trial court.
Just a question, assuming arguendo, we accept Mr. Frost's arguments, and he asks us to reverse and do a declaration, what does that do to your other causes of action? Do they just go away? Res judicata, you can never bring them up again?
I think if it's a remand and we're trying this over again, my claims become back to life.
But I don't think he's asking for a remand. Maybe I'm misinterpreting. He's asking for us to construe the trust in a manner favoring his position. And I even think he's asking for an award of attorney's fees without a remand or things along that line, but no remand. So if we were to agree with them, all those other causes of action go away?
That is correct, Your Honor.
Okay.
If you render in this case, my cause of action do not come back to life.
And that would, because one, I guess, part of the rationale there would, your client would not have standing at that point, right? He would be divested of any interest.
If the amendment truly did take my clients out of the entire trust completely, I think the Texas Property Code says because we were at one time a contingent beneficiary, we still have the ability to claim our interested person status. And we briefed that up in the trial court's briefing and here at the Court of Appeals. So I think we still have standing at that point to be able to challenge some of those positions. I don't think that takes away our ability at all in the trust.
Let me ask
Did
you a
you
question.
non-suit your claims before the trial court?
We did. We told the court we were abandoning those claims at that time for the fiduciary, the undue influence, and the capacity.
Okay, so there was no non-suit.
Correct. There was no non-suit filed. That's correct, Your Honor.
Counsel, let me ask you the same. I'm going to ask you a similar question to what I asked Mr. Frost just a minute ago. Let's assume for a minute there's no amendment or that the amendment's no good. Okay. Let's go specifically to Article 7 of the trust instrument. The first sentence of Article 7 says, our trustee shall allocate the remaining deceased grantor's trust property to the survivor's trust. Now that's your client's property, right?
That's correct, Your Honor.
Okay, so your client's property goes to the survivor's trust. How do we get to Article 8 then?
Okay, if I can point out that there's one word right before deceased grantor's trust, and that's remaining. That remaining, if you look down in 704, if you remember, we're not only talking about the corpus, the real estate, we're talking about the income generated by those items until it gets transferred over to Allen. That's the remaining property that's getting transferred over to the survivor's trust. If somehow this real estate is being hay harvested, bees being kept, if there's some income that's being produced from cattle walking on this property, that could be part of the community interest for these both parties, even after Ellis has passed away, because it doesn't lose its status as a community property, even though he's passed now.
So I'm trying to understand your position. Your position is under Article 5, once Ellis passed away, your client received a vested interest of some type in this real estate, right?
That is correct, Your Honor.
Okay, so that has been a part of the deceased grantor's trust property because it hasn't been distributed yet until the administration wraps up, right?
That's correct, Your Honor.
But you're saying that for purposes of Article 7, it doesn't constitute trust property? That's why I'm confused about what you're arguing. Sure. Why would Article 7 not be the applicable article? Because 8 is conditioned upon there being no distribution up until you get to Article 8.
I think a little different than that is my interpretation. You can jump ahead to 8 and skip 7 if, in fact, both of them have passed away and there isn't a distribution that needs to happen to a survivor's trust. So I don't think 7 is mandatory. I don't think 7 has to happen before 8. I don't think they have to be sequential. But what I do think is that in Article 502, upon the grantor's death, it became irrevocable. And let's talk just for 1 second, Your Honor, about that word irrevocable. Ellis Younger knew when he was terminally ill in October 2014 that his wife was going to try and change this trust. He knew it for a fact. The record reflects she had already, prior to his death, tried to change the trust and make it 60% to Glenn, 40% to Allen. Ellis wouldn't have it. Ellis said, absolutely not. This will be 50-50 to both of my sons. They will both receive the same share. That is something that I want to guarantee. The purpose of this trust is the hand reaching beyond the grave, not taxes. This whole estate is worth less than $500,000. Neither one of them had tax issues they needed to be concerned about. Ellis needed a tool to be able to ensure his wife didn't do exactly what she did in August 2017 and try to evict her son from the property.
Of course, we don't get into that extrinsic evidence to determine what his intent was if we hold that the trust was is unambiguous, correct?
I do understand that, Your Honor. Please understand, we've pled ambiguity from day one in this case. That has been one of our defenses in the whole thing. I don't know why Mr. Frost believed that we didn't have it in there. It's in every one of our petitions, and it's in every one of the pleadings live before the court.
Let me ask you an additional question. Suppose we agree with your argument to say that your client received some sort of interest that was irrevocable at the time of Ellis's death. Look with me at the first sentence of section 7.04. To the extent that any of the deceased's grantor's trust property is allocated to the survivor's trust, which is what Article 7 covers, our trustee shall hold this property in a separate share of the survivor's trust during the surviving grantor's lifetime. If we agree with your argument, doesn't that give the appellant a life estate in the property for her lifetime and gives your client a remainder?
I think it's still limited, Your Honor, by the first sentence of Article 7, which says it's just the remaining deceased's grantor's property. I think it's just this income, this residual income we're talking about. I think the real estate all transferred under 5.02. I think at that point under 5.02, Ellis's wish was, I want my son Alan to receive parcel 2, the 50% I control as Ellis Younger. I want him to have that. And I want him to have half of my interest in any personal property or my separate property.
Would you agree that to the extent that any of the property constitutes remaining trust property, though, that under 7.04 would call for her to have a life estate, certainly in whatever that remaining trust property is?
And that is a very consistent reading with the sentences that come after it, which is to keep it separate, no amendment to that separate share, no ability to dive into that separate share. The whole purpose of that separate share is to allow this preservation for the inheritance to Alan and Glenn as Ellis intended from the beginning.
And that would give your client a vested interest, but it would be a vested future interest, not a contingent interest.
Not possessory interest, that's correct. And the trial court took a look at that and said, as part of this for the declaratory judgment, we're going to make sure that everybody stays kind of in the status quo while this is going on. No more amendments, no more trying to evict parties off the property, as that was the declaration she declared.
Well, but my reading of the judgment, certainly as to the real estate, is that she recognized your client as having a present vested interest and is basically saying 7.04 doesn't apply to the real estate.
Doesn't apply to the real estate. That is correct, Your Honor. That's the way she read it. And she took basically that deceased grantor's trust and said the property itself went in there and jumped straight to Article 8, which is where that distribution would occur, because it was upon grantor's death, we have an administration and distribution, not years and years and years later as an expectant interest in the property.
Then I guess one of my questions is how do we know what trust property is remaining and what trust property is not remaining when we get to Article 7?
Sure. And I think if you read Article 502 and it's the articles around it, that deals with the specific gift of what Ellis intended at the time of his death. Basically, almost a will to the two beneficiaries in his estate. That property can continue to generate income, can continue to generate additional funds for and to support his surviving grantor. But the distribution itself is supposed to happen at the time the trust becomes irrevocable. After some administrative period. So you got to pay the death taxes, you got to pay the IRS, you got to pay whatever it is that's administrative, but we're talking weeks, not years, for the distribution to occur.
Now, a question or several questions with regard to irrevocable. Are you suggesting that because they made it irrevocable, or the terms of the trust were irrevocable upon Ellis's death, that means they could not change the manner of distribution intended by Ellis because they used the word irrevocable?
Yes, Your Honor. I think that's true. I think.
Okay, assume that's true. Well, assume was the intent. But if you have a provision in the trust that allowed the survivor, mom, so to speak, to dispose of the property, will that ability to dispose or assign or move around or whatever continue even though the trust is irrevocable?
So if you interpret irrevocable trust to include real estate that's going to the survivor's grantor's trust, then yes, I think that conflict comes up. And that's the problem that creates that ambiguity. The only time that ambiguity, I think, is resolved, Your Honor, is if there is no real estate coming through to Article 7.
Okay, is that
Because-
ambiguity related to what opposing counsel described as the definition of separate share?
Yes, Your Honor.
And then the ability, the surviving spouse's ability to go on and meld everything?
If the real estate is in Article 7, then reading in 704, the first two paragraphs consistent with the third paragraph, to me, becomes impossible. I don't know how you can do that.
So that
The
would
only
be an
way-
ambiguity as well, in your view?
It would.
A
That's,
reasonable ambiguity or whatever.
to me, that would be a very difficult ambiguity to resolve, because it becomes abundantly clear from Section 5 that the real estate is intended to be handed off by Ellis, and he wants to guarantee that's going to happen even after he passes. As to
And
all,
if there is an ambiguity, and it's a reasonable ambiguity, two reasonable interpretations that contradict each other, what is the result?
if there is a ambiguity that can be resolved in favor of any finding that the trial court made, then I think the appellate court has the responsibility to uphold and affirm the judgment below and resolve the ambiguity in favor of that judgment. And we've cited the case law for that in our brief pretty extensively, Your Honor.
So the court made findings with regard to intent?
The court made findings as to the interpretation of the trust, which basically tells us the intent of Ellis. The intent could be resolved by also remanding back to the trial court for that portion, but the testimony is going to be what we started off with at the beginning, that Ellis had always feared his wife was going to change the trust immediately after his death, and he needed it to become irrevocable, so that didn't occur.
Okay.
But to be clear, the district court did not say that the trust instrument was ambiguous.
Absolutely not. The trial court said it was unambiguous. It was over our objection that they found that.
I'm curious then, if she held, or she found that the trust instrument was unambiguous, and that's construed as a matter of law, why findings and conclusions were appropriate under the circumstances? Because that would simply be a legal question like you'd have in a summary judgment context or anything else.
That's correct, Your Honor. It gives her interpretation of the instrument itself, but it's de novo review at this court, so it really has very little instruction.
If we found the trust instrument to be ambiguous, then wouldn't that require a remand for a determination by the trial court as to what the settlor's intentions were?
That is the usual course, Your Honor. I think I've seen some case law that has said that if you can find a way to support what and affirm the judgment from below with the facts that are contained in the record, that's also an option. But you're right, traditionally we do remand it down to the trial court for that. And of course, even if there were a remand, even if this court were to render a judgment and find that somehow Mr. Frost's interpretation of the trust is correct, the declaratory action, if you look in our brief, makes it pretty clear. Those attorney fees have to be determined at the trial court. The Court of Appeals doesn't have to mess with that at all because of the equitable issue. And only the trial court gets to determine that, because the trial court can say, even though Mr. Frost is right, Alan gets all his attorney's fees as the non-prevailing party. So that's obviously a question that we would have to resolve below, not up here at the court. Just in conclusion, Your Honor, frankly, Ellis made it abundantly clear in his will and as it poured over into the trust what he intended. And I think the court can see from Article 5 and how it's intended to be transferred to the sons, this was the promise these children lived with all of their lives. And it was only because at the end of the day, Ruth did what Ellis feared she was going to do that we ended up in the court of the trial here in Seguin, Texas. And the result of that trial, I think the court, Judge Mirabel, got it right. I think she found the correct prevailing factors.
Thank you, counsel.
Thank you very much, John.
Thank you. Rebuttal, Mr. Frost? Hold on, are you on mute? Can't hear you.
Can you hear me now?
Yes, sir.
Okay, don't know what happened. Sorry about that.
Don't you love it?
We're actually doing pretty good. I've had a few of these not go quite this well.
Good.
Judge, there are no facts before this court other than that Ruth is alive and Ellis is dead. All of the facts told to you by Mr. Morris are not of the record. They are not relevant. And frankly, they're not correct. It is not true. The purpose of this trust, the stated purpose of this trust, was not to protect a son's interest down the road. We can look at the trust instrument to determine what its purpose was.
Well, real quick
Void
question
taxes.
with regard to something I asked opposing counsel about the trust referring to the will in any way. Did you find anything?
I
know
did
that's
not
related.
find, I searched for the word will. I did not see it start with a capital letter, but I didn't finish my search.
Okay.
I didn't find it, but I can't confirm for sure that it was not in there.
Would you agree, though, that when you have documents that are executed at the same time, that you necessarily can read those two documents together if they are related to one another?
No, Your Honor. I think the law is pretty clear that we use the four corners rule to determine the intent to the extent that we need to, and only where there's ambiguity. And again, Judge, it's vital that I explain to you why there's not ambiguity here. Okay.
So if you,
Please,
is it
go
the
ahead.
same rules of construction with regard to interpreting writings in
Absolutely.
general, like contracts?
Absolutely. Absolutely. Look to the government code. Look to the
Well,
canons of construction.
Okay, would I be mistaken in saying that when you have various contracts executed at the same time, that you can look at the various contracts to garner the intent, as long as one of those contracts doesn't say this voices the intent and supersedes all other documents?
Judge, I don't have that document in front of me. I don't know the date for sure that it was executed. I don't believe, if you read it, I don't believe it says what Mr. Morris purports it says. But our first prerogative in determining intent, if we need to, if there's an ambiguity, assuming we need to, is to look at the instrument itself. And what this instrument talks about is tax concerns and providing for the surviving benefit. There is no mention whatsoever of providing for anybody else in this trust until
The
everybody
provision
else
that
is
talks
dead.
about separate share, does it specifically reference the taxes?
Yes, it does. Absolutely. And I would refer the court to section 7.04. And Judge, Mr. Morris seems to have conflated two terms here, and this is an important distinction. The separate share referenced under 7.4 is in no way connected or referenced to the word share referenced in the chart on top of Article 8. We're not talking about the same things. That's just a chart saying name, relationship, and what the share is if we get to Article 8.
So the
A
term
separate-
share means two separate words? Has two
The term separate share has a clear and defined meaning under 7.04, and the word share, as it's used in the table in Article 8, is referring to a different share. This is talking about half of real property and half of the other assets, and half of real property and the other assets. The share here, while it's talking about the same properties, it's doing it for a different reason. It's for tax reasons. It's not for purposes of setting this up to be distributed down the road under a future article that has not vested yet. And Judge, if I could please walk the court through what happened to Ellis's half of the community property quickly.
Are you telling us to be quiet so you can talk?
I am asking the court for the opportunity to explain this in the last minute that I have, if it pleases the court. Section 501 is important. It defines what surviving grantor's trust property is, and it defines what deceased grantor's trust property is. The administrative trust in 5.02 was in the event there were taxes. This was not a taxable estate. Ellis's share fell into the administrative trust. I'm talking about his deceased grantor's trust property share, which we know is essentially his half of the community real property. Okay, jumping forward to Article 6, disposition of the tangible property. This is not at issue in this case. The only thing that's left is is top of Article 7. Our trustees shall allocate the remaining deceased grantor's property. We are talking about his half of the real property as defined herein, and the directions on how to handle his separate real property are outlined in this section. The court cannot ignore it. We're asking the court to reverse and render a judgment interpreting this trust as it is written based upon two facts. Ellis is dead, Ruth is alive. That's it.
Chief, may I ask a question?
Sure.
Article 7, it says our trustees shall allocate the remaining deceased grantor's trust property. Are you saying that the word remaining has no particular meaning there? That there's
And which section, Your Honor?
first sentence of Article 7.
Correct. Our trustees shall allocate the remaining deceased grantor's property, meaning after any taxes came out into the administrative trust, meaning after any personal property went to Glenn under Article 6.
So
After we take that property out, what we're left with is the real property and the intangible personal property of which there was none.
So the deceased property, the deceased grantor's property is separated and set aside, and then we go through the administrative process under Article 4. And your argument is that the word remaining here refers to whatever is held at the end after that property is administered and taxed.
After we walk through the conduits of Articles 5 and 6, we get to Article 7, and it says whatever's left after we've taken out property pursuant to Articles 5 and 6.
And so I guess under Article 8 would be a nullity then, because there would be no remaining trust property ever.
Well, we don't know yet. Article 8 does not kick into legal effectiveness until Ruth dies. It's not right for this court to determine what Article 8 says. We have to wait until Ruth dies. This court needs to interpret what Article 7 says. Any question about Article 8 needs to be determined at a later date. In particular, when you look at Ruth's rights under Article 7 to liquidate the trust for her own benefit without limitation. It is clear that this trust was set up to benefit the surviving spouse to every extent possible, and the kids were an afterthought. Moreover, she can appoint under 7.09, which is dispositive of this case.
Thank you, counsel. Any
Thank
other
you, Your Honor.
questions? Thank you very much for your arguments. Your case is submitted, and we will be in recess. I do want to thank you for appearing this way. It's different. It harkens back to Star Trek and a few other things, and I guess that is the way the future is here. But again, appreciate it, and we will be in recess.
Thank you, Your Honor.
Thank you.
Appreciate it.